Hi, this is Cynthia Ho, and we are going to be talking a little bit about trade secrets. So, to get started, let's talk about trade secret law. Are they uniform? The short answer is no. So, for trade secrets, there are actually both state and federal trade secret laws. Most states have adopted the Uniform Trade Secrets Act, which sounds like it's uniform, but because the act has terms that are not defined, then that means that state laws are not identical because different states have interpreted these differently. So we have different state laws, even though we have all, not all, but most 48 states adopting Uniform Trade Secret Act. And then in addition, there are federal trade secret laws under the Defend Trade Secrets Act. You may think that federal law preempts the state law, but that is not the case. So basically today, oftentimes a trade secret plaintiff will be filing both federal and state trade secret claims in the same lawsuit. As to which state law applies, that's going to be a complicated issue in terms of conflicts of law, deciding which state's law applies, which is outside our discussion, but just something to keep in mind. It's not necessarily where the courthouse is that you file. Now let's talk a little bit about what is a trade secret. Can it be anything? Could it be a treasure? The short answer is no. Trade secret isn't a thing, rather it's information that has two key characteristics. First, that information has to have value, and that economic value is actual or potential from not being generally known. So while a treasure, a thing, can't be a trade secret, the location of treasure, such as under the sea, could be a trade secret because it could be valuable to have the identity and a path to find that treasure. But that's only step one. The second thing you need for a valid trade secret is that the secret is, in fact, reasonably secret. Not absolutely, but reasonably. As to what's reasonable, that's a key question that is often the subject of litigation. You don't necessarily have to have a confidentiality agreement, although that can help. It's a fact-based consideration. You must probably at least tell people the information is confidential, because otherwise how would they know? You could alternatively stamp documents, etc., use keys, electronic or otherwise. But in terms of the first issue, in terms of valuable, it can be valuable without regard to whether it's used in a business, although usually value is something that businesses would want, and the trade secret need not be novel or even complex. Now, you may have heard that trade secrets can be customer lists and formulas, which is true, but notice I said can. Most importantly, a trade secret only exists if you have both of these two issues. It's valuable and it's kept reasonably secret. Now, if both of these things are true, then the trade secret can potentially last forever. But if it's ever disclosed, then it terminates. You might still have a right against somebody who improperly disclosed it, but as to everyone else, the trade secret is now out in the open. Now, talking about rights, the first thing to mention is that violation of trade secrets is called misappropriation, not infringement. So misappropriation is to suggest that someone has done a bad act. What's the scope of the right? Basically, the scope of the right means that you have rights not against everyone, but only against those who did something improperly and had a legal duty to you. So basically, a trade secret right exists if someone acquired the trade secret by improper means, i.e. they breached a legal duty. So for example, a employee who stole the information, or disclosure use of a trade secret by someone who used improper means to get the trade secret or knew the information was obtained through improper means, even though they didn't do it themselves. So a trade secret owner doesn't have the right to exclude people who independently discover the information, unlike a patent. And the trade secret claim will exist still against someone who improperly discloses, even if the trade secret terminates as to everyone else, as I mentioned before. So one last thing about remedies. One remedy, obviously, would be a permanent injunction to prevent people from continuing to use the trade secret. But sometimes courts also, in framing a permanent injunction, will consider how long it would take someone using proper means to get the same thing, i.e. reverse engineering. The reason why is usually the court wants to be fair and not give longer than necessary to the injunction, because that could unduly restrict individuals or entities from pursuing lawful employment or business. So injunctions for trade secrets definitely have to balance the rights of the trade secret owner with other rights and interests as well. Hopefully that was a helpful overview for trade secrets.